Morning, everybody. I'm Tane Minnick, and I am a Pinnacle business guide. I help companies get unstuck and scale. And I do that in three ways. We look at the internally, we look at the operations, we build infrastructure and scaffolding to support the organization internally. We build teams that thrive and become leaders leading these operations. And the third way is from an external perspective. We build strategies that help you dominate the marketplace. I also am a Vistage chair here in Orange County, California. I have several CEO peer groups and a key executive group, and I would love to have you reach out and talk about membership and as a Vistage member. With me today, this is very, very crucial here in California, is PAGA claims. We've been hearing a lot about it, and we're going to talk a little bit more about it with Mohammad Khan. Welcome, Mohammad.
Thanks so much for having me, Tony.
Yeah. Mohammad is as a business attorney here in Orange County, California. And, while he looks like he might be 12 or 13, he's actually been an attorney for 10 years. So I just want to clarify that.
I'm going to keep this clip and show it to my wife later. But keep
And we've just literally been talking a little bit before we came on this interview, a little bit about PAGA.
Yeah.
PAGA is coming up also in the elections, which Mohammed is going to share a little bit more information about that. I chair several CEO peer groups. Several of them, one of them is through Vistage. And it's something that I'm hearing a lot about right now. And I got to be honest with you, it's a lot of grumbling. It's a lot of frustration around it. So I just wanted to take some time with you, Mohammed, to kind of explain what PAGA is and define it, shape it. What do we need to do? What do CEOs need to do to be aware of it? So if you want to hear more about PAGA claims, and this is specifically to California, correct?
Correct.
Just specifically focused to California. So those of you who are chiming in, stick around if you want to learn about some California law. Okay, so why don't we kick it off with explaining, first of all, I'd love for you to take a little bit of time to just share a little bit about yourself first, and then we'll get into a conversation about PAGA. So tell us a little bit about yourself.
Great. Well, Tony, thank you so much for having me. My name is Mohammad Khan. I'm the managing attorney of M&K Law. We're a boutique law firm that specializes in providing services for businesses and employers. We do defense work in these employment disputes. We also do transactional work. We help companies buy and sell. And then we just help with general compliance, whether it's through HR and other items like that. We've been around for 4 years now in July. And prior to that, I had been practicing as a partner and CEO of a mid-sized firm in Southern California. So I'm coming up on 10 years of practice in the law, and it's been great. So yeah, that's a little bit about me. And then if you're okay, I'll go ahead and jump into PAGA and speak a little bit about that.
Yeah, absolutely. And let's just start at sort of the high level, what exactly is PAGA? So let's kick it off there.
It truly is a four-letter word, right? So you hear a lot of people talk about PAGA, and there's not a full understanding of it, especially with businesses. But PAGA just stands for the Private Attorneys General Act. And it's a law that was created. So taking a step back, the state of California has a bunch of labor laws. These are rules of the workplace that require employers and employees to act in a certain way. Anytime a rule is broken, anytime there's a violation, there is a statutory civil penalty attached to that. Now, what's happened is the state of California doesn't have enough resources to make sure everyone is acting and behaving in accordance with these rules in every business. So what they've decided is essentially, hey, let's privatize these actions, these lawsuits, and deputize all of the employees. If something's not happening in accordance with the labor code at the company level, what businesses are now having to look at is an employee potentially bringing a claim on behalf of the state of California against their employer. This is why some of your viewers might have heard the nickname of this law, PAGA, is the sue your boss law. Now, what happens within that context is any current or former employee can stand as a plaintiff in sort of a collective action against an employer for any one of the technical violations that are available under the labor code. Generally, what happens is a current or former employee is aggrieved or they feel wronged in some way. and they will go to what's called a plaintiff's attorney. Those are the attorneys that represent the employees and file the lawsuits. Now, none of these employees, generally speaking, even know what PAGA is or the labor code, but they'll go to the plaintiff's attorney and say, hey, I was wrongfully terminated, or I was treated poorly by my employer. And the plaintiff's attorney will then develop the case a little bit and ask questions about, did you get your meal breaks? Did you get your rest breaks? The plaintiff's attorney will then make a determination that, hey, you know what, there's something here, and I think this isn't just a problem for this employee that came in. There's more employees at that company that were facing this, and they'll make a decision to initiate a PAGA claim against the company. Now, to do that, you have to actually file an administrative complaint, a notice with the LWDA, that's the Labor and Workforce Development Agency. Once a plaintiff filed that, then the employer will get a notice saying, hey, you have this potential claim pending. The other things that I'll tell you about PAGA is it's an interesting law in that we already talked about the dynamics of the state of California and the employees, but the penalties within PAGA, 75% of all of those funds, those penalties that come from the employer, they go to the state of California. Only 25% go to the actual employees, the aggrieved employees. And then additionally, this is where the incentive structure is kind of messed up. The plaintiff's attorney gets their full attorney's fees and costs to bring these lawsuits. Now, you might be wondering, 75%, 25%, is this really that important to my company? How much money are we talking? Well, those labor code violations that I had spoken of at the beginning, those carry with them a $100 penalty for the first violation per employee per pay period. And then it's $200 per employee per pay period thereafter. Let's just use some round numbers. Let's say you have 50 employees, both past over the past year and current. And let's say there's one violation. And let's say you pay those employees every week, 52 weeks. When you start multiplying that up, we're talking about hundreds of thousands of dollars. And then when you compound that with additional violations, it's millions and millions of dollars.
Wow.
This could be devastating to any business in California. The last point on the sort of the background piece of PAGA, there is a ballot initiative that is on the November election ballot, and it's to repeal and replace PAGA. I encourage everybody to go and take a look at it. The initiative purports to have 100% of the penalties go to the actual employees, and they try to strip out some of the incentives of the plaintiff's attorneys bringing these lawsuits. Again, the intention might be right. We all want a workplace where the employers and the employees are acting in harmony and following the laws, but we don't want to incentivize it where we've seen this huge proliferation of lawsuits being filed against companies.
Yeah.
So that's a little background on PAGA in a
Right.
nutshell.
Right. Yeah. Thank you for that. So, yeah, it sounds like it can be a substantive kind of penalty for organizations. So what, how does this differ from other kind of employment lawsuits?
It's a great question. So the labor code applies to all employees, right? There's something called a class action, and some of your viewers might have seen movies of class actions. That's where a collective group of employees or collective group of aggrieved individuals sue one entity. The PAGA lawsuit is actually where one employee, if they are aggrieved, let's say they didn't get their overtime paid properly, and there's other potential aggrieved employees, they can bring a claim on behalf of all of them. In addition, even if they didn't have another grievance, let's say they were forced to work off the clock, they can stand in the shoes of those employees as well and add that as an action as well. So it's very different from you have that one employee that left and is suing you for failure to give reimbursements or something like that. Now you're dealing with a whole class of employees, and generally the statute of limitation, the period of time that this goes back, is 1 year from the grievance. So they can be really, really punitive.
Okay. So just to go back, so I understand clearly, so the PAGA claim is generally not just one employee, but they try to find multiple. Okay.
Yep. And the plaintiff's attorney just needs the one employee. They don't need the whole group. They just need that one person that can step in the shoes of all of the employees.
Okay.
And to your point, that's why, because it's not just one employee, it's the magnitude is much larger. It's all of your employees. It gets really expensive.
Okay. Okay. What, I'm just wondering what kind of employer practices could lead to, or lack of practices, could lead to PAGA claims?
So another great question. So one of the ways we can kind of look at this is what are the common violations in this space? And a lot of employers and viewers might be listening and think, you know what, I run a really clean shop. I take care of my employees. We have a good relationship. I don't really have much to worry about here. But I'm here to tell you that that's just not true. The violations under PAGA are highly, highly technical. So let me give you an example. Let's say there's a company that is operating at a suite 100. And they are doing well and they decide to move up to suite 101. Well, a violation under the labor code is the pay stub accuracy. So let's say on the pay stub, it says works for ABC Corp, suite 100 on the address. ABC Corp moves to suite 101 and forgets to go back to their payroll provider and says, hey, please update this. That is a violation that carries with it $100 for the initial violation, $200 for each thereafter, for each employee for each pay period. So again, highly technical. It's almost impossible to comply with all of the requirements of the labor code. But something like that can quickly, depending on the amount of employees you have, spawn into $1 million exposure. Yeah. Other typical violations are off the clock work. If you have hourly employees and you're calling them off hours to ask them questions and they're not being compensated for that, that can get you in trouble. Having employees work overtime and they weren't compensated, whether they're whether they're punching out at the end of a shift and they're hanging around to help offload some inventory or something like that. Mm. And then two other common ones that we see a lot are meal and rest break requirements.
Yeah.
Did they get their 30-minute meal breaks? Did they get their 2 rest breaks in an 8-hour shift? And then finally, are we reimbursing our employees for items that are reimbursable? And if we're not, any one of these violations could subject you to PAGA penalties. On average, these types of lawsuits, at least in California, and the data shows, they settle for about $1 million. They go on for years and years just to kind of litigate them. And we've seen a huge increase in the number of PAGA lawsuits that have been filed in the thousands in the recent years, because plaintiffs' attorneys are starting to find out, and this is me being cynical, but plaintiffs' attorneys are finding out that these are high exposure cases with a lot of attorney's fees. So they're filing these claims wherever they think they can prevail. Mm-hmm. And the last point about this is some folks might be thinking, we have insurance coverage, we should be okay.
Yeah.
Frankly speaking, most of the employment practice liability insurance, the EPLI insurance coverage, that it doesn't cover PAGA claims. It doesn't cover some of these wage and hour claims. So it's not enough to just say, you know what, there's these high exposure areas and they're technical, but we have insurance. You got to be really proactive and think about what are we doing intentionally to prevent these things.
So just a follow up to that, Mohammad, is there a type of insurance that does cover this?
Unfortunately, most carriers are out of the business of covering these type of items. In fact, I've spoken to some carriers where they've gotten out of the wage and hour coverage, and more carriers in California, given all of the lawsuits that are out here, they're less inclined to cover other items. Now, carriers will cover wrongful termination, disability, discrimination, things like that. But it's difficult. It's not impossible. It's difficult to find carriers that cover wage and hour. And if they do cover wage and hour, the deductibles and the premiums are punitive.
Oh, my goodness. Wow. Okay. So well, before we go there, do you have any stories or anecdotes that you can share that, I mean, I know, everything is confidential, so you may not have anything that you can share, but if you do, it'd be interesting to hear.
Yeah. My experience, and my parents were employers. I love employers. I love the state of California. I believe employers are out to do good for their employees and for the state. One example of this is I had a client that they have employees that there would be a work truck that would come not a work truck, sorry, a catering truck that would come to the work site, and they would have breakfast basically available, and employees would want to take their 10-minute break to go to the work truck, to the food truck, order some food, and then eat the food at like 10 o'clock. Mm-hmm. What was happening is the employees could not finish. They couldn't order the food, get the food, eat the food all in 10 minutes. So the employees went to the employer and said, hey, can we combine our afternoon rest break and our morning rest break into one and use that 20 minutes and be able to get this breakfast, this midday breakfast in. And the employer, trying to do a good thing for the employees, said, sure, we'll do it. Sure enough, that's a violation. They got hit with a class action, and there's significant exposure, both class action wise and PAGA wise. So it's unfortunate. It's almost as though no good deed goes unpunished. A lot of these employers are out to help their employees and to provide an environment that they enjoy working at, but it lends themselves to exposure. And that's why we have to be very, very careful with some of these technical violations.
So just playing along that story or that theme a little bit, what would have been the best way for the employer to handle that situation?
Two options: either say, unfortunately, the state of California doesn't allow it, so we can't do it. Or they could say, you know what, we'll give you your 10-minute in the afternoon, and we'll give you 20 during the prior shift. The tough part there is employers also need to ensure productivity. So now, instead of giving their 10 and 10, now they're getting 30 minutes of rest breaks, plus they're getting their lunch break. So those are the two options: either take a hard line and say it in a tactful manner to your employees that, I feel for you, unfortunately, we're not allowed to do it because of the laws of the state of California, or go ahead and give them more time for the rest break.
Yeah, interesting. Okay, thank you for that. Thank you for sharing that. Very interesting. So let's get to maybe the part of what employers need to do to kind of be proactive, to, circumvent this from happening. Yeah.
Yeah, absolutely. So there's at least four concrete things that employers can do right now to help proactively prevent PAGA exposure. You can't 100% wipe it out, but there's four things, and then I'll give a fifth that is worth consideration.
Okay.
The first is to do what's called PAGA audits. The first thing that you could do within that is you don't even have to hire an attorney for this. Simply check if you're paying your employees weekly or biweekly. If it's possible and practical for you to switch your payroll to biweekly, that immediately cuts down the penalty periods. You know how I said per pay period? If you have 52 as opposed to 26, the exposure, the multipliers are a lot less. Now, if you did do this, you want to give your employees notice. I like to roll it out over a 6-month period where you let the employees know, hey, we're going to make this change, usually at the start of the year. But if a company is looking at doing that, that's something that could help right away. Other items are to look at, review, update, and revise your employee policies and procedures. Consider drafting new employee handbooks if needed. Check how you do rounding on punch in, punch outs. Check what your break policies are. Like, for example, the story that I just had conveyed to you. Look at how we reimburse employees if we do auto deducts on their payrolls. Are they working off the clock? Look at all of that. And then also consider if you have any meal break waivers, have those reviewed. And there's something in the state of California that's allowed that's called alternative work schedules. And that's where you can have an employee work 4 days a week, 10 hours a day, and they won't incur overtime. See if that's appropriate for a class of your employees. That's number one, is do the PAGA audit. And usually you'll need counsel to do this. So I strongly encourage you, reach out to your attorneys. And this list that I'm giving, you don't have to use our firm. You could, if you have an attorney that you like and trust, you could say, hey, I'd like you to do something like this for us. The second thing you can do is conduct manager trainings on basic wage and hour rules. I highly recommend that we do this as companies. The C-suite, the owners, they probably have enough knowledge at this point about the basic wage and hour rules, but your frontline managers might not. So have an attorney come in, do a 45-minute webinar session where they kind of take them through high level of exposure areas and what the rules are to make sure that employees are following those rules. And if they're not, that the documentation is in place to help provide corrective action. I recommend doing those on an annual basis.
Okay.
Number 4 is implement something called an arbitration agreement. It's a little technical for this setting, but recently employers have finally gotten a win in California. And the California State Supreme Court has allowed for arbitration agreements, which help break apart the ability of collective actions. And those PAGA claims have to be arbitrated on an individual basis in arbitration, which is really helpful from an exposure standpoint.
Okay.
And then number 4 is implement attestation forms. So there's a split in sort of guidance on when you give these attestation forms, but they're basically forms that say, hey, I received all my meal breaks, I received all my rest breaks, and they click a box and that data gets stored so that later the employee can't come back and say they didn't get that. Some people say to do it when you give them the paycheck. So when they get the paycheck, they click it and then they get their check. There's some authority out there that says, well, the employee might have been forced to sign the form because they wanted to get their paycheck. So what I recommend is do it on the off weeks. So if you first week is payroll, second week do a attestation, third week another payroll, fourth week attestation. That way you have the data internally to show that these employees are getting their meal breaks, they're getting their rest breaks. The last preventative item that companies can consider, it's a little overkill, but it depends on your exposure, your exposure analysis and what you're willing to put up with or not, is you can actually hire a statistician. So we work with groups that will pull all of your payroll records and we'll do an analysis to see currently in real time, are people getting their meal breaks? Are they working overtime? Are they getting paid for it? What does the data actually show? And that way you can see if you're compliant or not. And if you're not, you can start taking corrective action immediately. So again, those are the 5 preventative actions that one can take. But again, it's not 100%. You could still get hit with a PAGA claim, but that's at least helps reduce the exposure as much as possible.
Yeah, I think this is really kind of critical and key. I'm just going to repeat back to you the 5, make sure I got them right. So the PAGA audit was number 1. Yep. Number 2 is making sure that there was manager trainings, that all the managers are trained. And what I want to just highlight is you said with an attorney. So an attorney's coming in and training them because they really are the ones that know and understand and can answer all the specific detailed questions. So I think bringing in an attorney to have those conversations with your managers is really key.
Tane, to that point, I've done these trainings and we tend to elevate managers in our companies because they're good performers or they show certain traits, but we might not necessarily always arm them with the tools they need. When I come in and do these trainings, they're scheduled for 45 minutes and then there's a Q&A period. The most useful questions are coming out and there's this sort of enthusiasm from the managers to learn more and ask questions. So I think clients and viewers will be pleasantly surprised at the impact it has on their frontline managers.
Yeah, I couldn't agree more with you. The third one was the
attestation forms. That's just basically, hey, I got my meal and rest breaks.
Yeah. So the employer's saying, yep, check. Or the employees are saying, yes, I got it and I'm good. The fourth one, what was the fourth one?
Oh, the arbitration agreements. Get those in place and roll those out. Yeah. And those will help quite a bit.
Okay. Yeah. And the fifth one being hire a statistician. So
yeah, exactly.
Okay. That's really great. Thank you for that. That's a terrific list and a very specific list that people can kind of take a look at it.
Yeah.
Okay. So let's say that the company gets served. Like what happens at that point? What should they do? What's their first line of action and defense at that point?
Yeah, I'm glad you asked that because we do this preventative stuff. Some people might be in tune with the preventative stuff, they get on it, and some might not. And now you've been sued, and now what? You have to act fast. The first item is to inform your insurance carrier. Now, I've already prefaced this that more likely, assuming you have insurance, it's not covered, but at the very least, you want to contact your broker and say, hey, I've been served with this. I've gotten this notice. Please advise if it's covered under the policy. Even if they come back and say no, you at least want to initiate that on the off chance that something might be covered.
Yeah.
And you should do that, by the way, with any lawsuit that you get. If you have insurance coverage, whether it's EPLI, employment practices, if it's directors and officers, insurance, whatever it is, anytime you get a lawsuit, immediately think, let me get it to my broker, or let me get it to the carrier and see if it's covered. Next is you're going to want to act fast and hire counsel. The reason why you're going to want to hire counsel is PAGA allows for a cure period. It's 33 days after you receive the notice. So going back to that early technical violation of pay stubs, let's say you only have 20 employees and within those 20 employees, you forgot to correct your address halfway through the PAGA period. You can actually go back and correct all of that and send out new pay stubs and prevent violation there. So it's not always applicable, but think about it, consider it. And if you hire counsel, because 33 days goes very fast, if you hire counsel immediately, you get a jump start on, can we cure anything? Do we even want to cure anything?
Yeah.
And then at that point, you're going to want to, if you haven't done the audits already, you're going to want to do an audit again, and you're going to want to make any corrections that you can, whether that's in your handbook, your policies and procedures. You want to immediately correct anything that you're not doing correctly. That way you stop the exposure going forward. So you want to do that. And then the last two items is you'll want to do an exposure analysis with your attorney. And that's usually when they go and hire the statistician as well.
Okay.
When we look at your pay records. And that's important because you as a business owner, you need data, you need information, you need to know right now, what am I looking at? What are the options? What decision should I make? You don't want an attorney that doesn't tell you this right away. They sit there and bill you 100 grand, and then they come to you and they say, hey, Mohammed, you're in trouble on this one. We've got to settle it. No, let's do the exposure analysis right away. Let's get the data in front of the decision makers. Let's get the statistician in and see what violations are there, and what's actually might be owed, what might not be owed. And then once you have that, then you can go into the final step, which is assess early settlement. Is this something that needs to be settled right away? Is this completely bogus and there's nothing here? Let's fight it. Let's have that discussion early on and align to some kind of a roadmap or plan between your counsel and the company, so that then you can move forward with clear eyes rather than having this uncertainty of what happens next.
Terrific. That's great. Thank you for that. Mohammed, is there anything else that I haven't asked you that we haven't talked about that you think would be valuable for CEOs and owners to know about?
Yes. No matter how good your policies and procedures are, no matter how good your attorney is, 90% of employment law comes down to communication. You got to communicate with your employees, right? And if there's somebody that's not meeting expectations, you have to communicate with them and get it on their radar, because it shouldn't be an adversarial relationship. It should be a joint relationship. And if someone is falling below your expectations as an employer, it's not enough to look the other way and say, I'm too busy, I'm not going to deal with this right now. I'll give you an example. You have an employee that the second week on the job, they start coming in 30 minutes late, and the manager is swamped with work and they don't have time to address that issue. They just shake their head and hope that it gets better. 6 months later, this employee continues to come in 30 minutes late, and the manager's had enough. And they say, enough, we're terminating you, you don't come into work on time. Meanwhile, there's been no documentation. You haven't had one discussion with the employee, and the employee's thinking, I thought there was this magic 30-minute grace period. I've never been written up for it. Now the employee's super upset, and now they're angry enough that they're going to go and search for a plaintiff's attorney to sue the company. If you increase if you increase communication, you document the process, you write people up so that you can coach them up, then it won't be a shock if they're let go. If that same employee was written up on the first instance, you go to Mohammed and you say, hey, Mohammed, I noticed you came in late. Is everything okay? Right? You lead with empathy. On the third, fourth time, you say, Mohammed, you know what? It's really critical for you to be here on time. You're not coming here on time. We've got to write you up. Let's tighten this up and move in the right direction. Then once they've gotten their third write-up on not coming in on time, it's not going to be a shock. They might disagree with it. It won't be a shock. And when you reduce the temperature on terminations, it reduces the likelihood of a lawsuit altogether. So that's sort of a tidbit that has very little to do with the law and more to do with that sort of communication and how are we interacting with our staff.
Yeah, great. And great to add that to you had that great list of 5 sort of ways to sort of prevent. Let's add communication to that list too, because that's another really critical point. Excellent. Mohammed, thank you so much. This has been a wealth of information, very specific, very clear, and I know everyone's going to find this super valuable. So thank you so much for your time today.
It's my pleasure. Thank you for inviting me. I love businesses. I love employers. I think they're the lifeblood of the state and the country. So if anybody ever needs any help, feel free to reach out to me.
That's terrific. Well, thank you so much.
Thanks, Tony.